Honorable Vice President.
Senator Shrikissoon?
Yes.
One more. Okay. Yeah, we need one more. Senator Shrikissoon.
Thank you, Mr. Vice President, for allowing me the opportunity to contribute to this very important debate. I want to say that while the bill is just about one amendment or two amendments, just about 4 or 5 lines, I don't think that the length of the bill has anything to do with the importance and relevance of the bill. And so it is on that note that I chose to, that I did ask to contribute towards this bill. And today what we're debating or what we're considering here is the reduction in the rate of interest on judgment debts. And we're seeing in the legislation being proposed here a reduction from 12% to 5%. The minister, the honorable minister, in his opening arguments today, did signal that one of the reasons for lowering the debt level was that of falling interest rates. However, as others would have said before me, that there was no justification for arriving at a nominal value of 5%. So while he did indicate falling interest rates, there was no justification for that of 5%. What I would like to say, though, on the last occasion that this rate on judgment debts was amended was in the year 2000. And if we look at the prime lending rate at that time, in September 1997, it was 15%, 1998, 17.5%, 1999, 16.5%, and 2000, just on average, about 16.5%. So what we saw was a rate that was being used that was very close to the prime lending rate. What is more is that we're aware from the Gurley report, as Senator Mark spoke on, that this report was done in about 1992, 1993, that recommended a percentage of 12%. And if you look at the prime lending rate at the time the report was issued, it was also just about 12%. So the original recommendation in the year 2000 of 12%, which was as a result of the Gurley report, which was prepared in about 1992, 1993, the prime lending rate at that time was to around 12%. So that there's some element of consistency in the argument that the point or the rate of interest that was used on judgment debts at that point in time was very similar to that of the prime lending rate. And the reason why I'm saying this or bringing this argument together is, as I quote from Hansard in the year 2000, the Honorable Attorney General at that time, Honorable Ramesh Lawrence Maharaj, says, creditors or debtors would not pay this money because they would believe they can hold back the payment, but in the meantime, the person who is supposed to get the money has to borrow from the bank and pays 10 to 12% interest. So what he was saying at that point in time is that if the judgment rate on the interest on judgment was 6%, but the rate, the prime lending rate or the rate at that time was 17%, then no one would be inclined to pay. Just let it go to court and let us be the benefit. Let us have a benefit of 6%. And so he's saying, in order to increase or to allow efficiency in the market, let the penalty for the defaulting person be the same as the prime lending rate. And it is for that reason, in my view, that 12% was used at that time. He goes on to say, and I quote from Hansard, if a debtor is not required to pay interest on monies due to his creditors, or if the rate of interest payable by law is lower than the commercial rate, that debtor will be inclined to avoid or delay payments for as long as possible. And so, because in order to bring it together, for there to be equity, the prime lending rate was used to influence the rate on judgment debts. And as Senator Mark said here, from the Gurley report, it says here that the recommendation from that committee is that the statutory rate of interest should be increased to a rate that is more in keeping with prevailing lending rates in the financial markets, as it is thought that the rate of 12% is more realistic. So while we're focusing on the 12% that was used, the logic behind the 12% is what's important and not the nominal value. Because what was being used was the rate of interest at that bank that companies would have been able to borrow at. The prevailing lending rate. And that's really the core of the matter, to bring it together so that there is balance on both sides. Now, Senator Mahabe referred to the repo rate, and the Honorable Minister of Finance said that we were in an era of falling interest rates. I would just like to say here that at present, until January 2016, we have an article here that's entitled, Central Bank Maintains the Repo Rate at 4.75% after 8 consecutive increases. Central Bank has maintained a repo rate of 4.75% after 8 consecutive increases. Where am I going with this? That we were in a rising rate environment between the period 2014 to 2016. And it is only because of the economic outlook of 2016 that was linked to the US market that the repo rate or the interest rates were held. It never went down. So between the period 2014 to 2016, we were in a rising rate environment, as evidenced by the repo rate. And I can quote the number of times that it was increased, but I don't want to go there. I don't want to go into that. But it was 8 consecutive times. So we're in a rising rate environment. And since January 2016, it was stabilized. So to use an argument of a falling interest rate environment in Trinidad and Tobago to justify a move from 12 to 5%, I am not too sure that I want to agree with that statement. Now, what is happening here is that a move from 12% to 5%, and the prime lending rate in our country right now is just about 9%. So if a company is borrowing financing for a project, they're borrowing at a minimum of 9%. If there's a dispute and it goes to court, it is saying that the judgment now of 5%, that they could be awarded interest charges, is insufficient to match the cost of capital for the company. And therein lies a significant issue. Here it is, a company utilizing debt financing at a cost of 9%, has a dispute with the vendor, the person who he's working for, and the best offer that you can get through the courts at this time is probably just around 5%. So even if the person who brings the judgment wins the case, he is still 4% out. And that is not good for the private sector. A sector that you are looking to invest capital at a time when a country needs it the most. It is not it's not a way that you can attract private capital when, in the event of a dispute, that the courts could be guided by a rate of interest that is quite lower than the cost of capital. And that has a significant implication for investments in our country. I would also like to say at this point in time that an interest rate very close to the prime rate of interest, is an interest rate that may deter people from going to courts or companies from going to courts if it could be settled at a lower rate outside. And therefore, the judgment, the interest rate on judgment debt should be one that is punitive, having to take a matter through the court system, tie up the court's time, and then award a result. It should not be that the court system or judgment from the court facilitates judgment against someone. It should be that through alternative mechanisms of resolving, the court should be the last place. It cannot be that the courts will be guided by a law that it brings favor to the person or the defendant in this case. It cannot be. And I'm saying this in the context of what is going on in our local economic environment in Trinidad and Tobago. According to a Guardian article published on June 12, 2016, the president of the Contractors Association, Mikey Joseph, has indicated that the state owes in excess of $2 billion to contractors. And I have been advised at this point in time that most of the contracts that are used before government and agencies that are building takes a form takes a contract form of FIDIC, F-I-D-I-C, which is really the International Federation of Consulting Engineers. And those concepts in that form of contract usually influences the contracts that are in Trinidad and Tobago, most of them. And I want to read a clause from that FIDIC form of contract that exists in most, if not all, the contracts in Trinidad and Tobago. And I'm also aware that the government is using some element of training or utilizing training in this form of contract. And it says here, unless otherwise stated in the particular conditions, these financing charges, meaning on delayed payments, because I'm reading 14.8 delayed payments on the FIDIC form of contract, delayed payments, and it says here, unless otherwise stated in the particular conditions, these financing charges shall be calculated at an annual rate of 3 percentage points above the discount rate of the central bank in the country of currency of payment and shall be paid in such currency. So here it is, you have a contract or a form of contract that dominates the issuance of, or that dominates the way in which contracts are prepared in Trinidad and Tobago. The law, according to the contract law, is saying that for delayed payments, a situation in which Trinidad and Tobago has found themselves is saying that financing charges shall be calculated at 3 percentage points above the discount rate. And my check today is saying from the central bank website that the discount rate right now is 6.75%. My calculation, 6.75% discount rate added to the 3% according to the FIDIC form of contract is saying 9.75%, very closely aligned to the prime lending rate of Trinidad and Tobago, which is 9%. The logic of 2000, that the proposed rate should be in line with the cost of borrowing, it is the same logic that is being used in contract law, which governs the way in which the government and the private sector handles their arrangements to build. And so we're seeing here, according to this FIDIC form of contract, 9.75% is being used. Now here's the challenge. If 9.75% is being used according to contract law, and this matter cannot be resolved and goes to court, then the court is so guided by 5% if this law is passed. How can the FIDIC form of contract, which is the primary form of contract used in this country, prescribing 3% above the discount rate, is now subject to a different rate that we propose today? Will private sector agree to invest in our country at this time when, through dispute and judgment, the rate of interest that they could earn is a lot lower than one, the prime lending rate, which is the minimum cost of capital, and two, the penalty according to delayed payments, according to the FIDIC form of contract that we use in this country. Is it consistent? And the answer clearly, in my mind, is no. It places the defendant at an advantage, given that the FIDIC form of contract is saying 9.75%, but the law today is saying 5%. I'm suspecting that there could be some element of problems in and among a private sector and contractors if this persists. We are told as well, and in Prime Minister's address to the nation on Sunday evening, he said at that point in time that he gave a mandate to operationalize procurement. How can you engage the private sector if the dispute resolution or the interest on judgment places those same companies at a disadvantage? You want to operationalize procurement, but the judgment debt on the interest on judgments, if there is a dispute, is not in sync with lending rates and places private capital at a disadvantage. More so, not only would it affect government and contractors, but foreign firms investing in Trinidad and Tobago, if a contract is worded and denominated in TT dollars, well, the jurisdiction of that contract is Trinidad and Tobago. And therefore, they too, their private cost of capital, if it's higher than the 5%, may actually say, well, I'm not willing to go there, because if there is a dispute and it ends up in court, and after multiple years, because we know the judicial system in Trinidad and Tobago is not as effective as it should be, awards them a rate that is lower than the cost of capital. What are we really signaling to private sector and companies that are willing to invest? The parliamentary staff of this honorable house provided a document for us, and they provided comparison of rates that were used in different jurisdictions for the interest on judgment debts. Canada, and they quoted specifically Alberta, which is 0.55%. That 0.55% applies to Alberta alone and not Canada. The rate of interest that is used in Canada, as can be found on the website of the Attorney General of Canada, is saying that there's an interest rate for pre-judgment and there's an interest rate for post-judgment. Pre-judgment, 0.8%. Post-judgment, 2%. What is prime in Canada? 2.75% or 2.7%. The penalty that is being used in Canada is that the interest on judgment rates, or interest rate on judgments, very closely aligned to prime. What is happening in New Zealand? New Zealand judgment debt is up to 7.5%. What is their prime? 9.2%. So it is below prime, but it's very close to prime. Prime should be one of the benchmarks that is used to determine the level of interest or the interest rate on judgment debts. If you go to Australia, the same document that the parliamentary staff provided us with, it's one, Senator Henry alluded to it, 1.5% their cash rate, which is very similar to our repo rate, plus 6%, which brings it up to 7.5%. What is the prime rate in Australia? 5.6%. Very close. What are we doing in Trinidad? 9% prime, 5% being proposed, a negative ratio or negative difference of -4%. One of the largest that we have seen here based on the information provided by the parliamentary staff. And that cannot be favorable. It is saying that if our disparity is so wide, we need to look at the logic that was used to come up with the 5%. Senator Mahabe referred to the repo rate. But the repo rate, as Senator Henry was saying, is not the cost of capital and not the cost that consumers or firms use or not the cost that firms get at a commercial bank. It is not the rate. The rate they use is the prime lending rate, or just about the prime lending rate. But Senator Mahabe in his contribution using the repo rate, I'm sure was thinking, just like Senator Sturge, of the average citizen on the street with a judgment. I am saying here, when you're looking at the companies and private sector, the companies that engage in investment in this country, that the prime lending rate, which is consistent with the logic used in 2000, which is consistent with the rates used across the country, and even Senator Henry, when he alluded to Singapore at 5.2% or 5%, the prime lending rate in Singapore at that time was also 5% or 5.2%. So the logic is clear and resounding that across the world, that the logic that is being used to come up with the interest rate on judgments is the prime lending rate.
All the cases you cited were below.
No, I didn't. I didn't. 5.6%, and the judgment was for Australia, and 7.5% for Australia. Judgment was 7.5%, 1.5% plus 6%. Prime is 5.6. So that's not incorrect. If you look at the UK is very punitive, very punitive. Prime in the UK is 1.25%, and their interest on judgment there is 8%. How many percentage points above prime? That's the only one that is so punitive. Everybody else usually settles within a 1 or 2% around prime. So that's the argument being postulated here this evening, or being put forward here this evening, that the rationale for determining the interest rate on judgment should be very close to that of the prime lending rate, especially if we are thinking of the private sector in this token. So I'm saying here today, as I close and I'm finished, it's saying that the rationale for arriving at the 5%, was not given. It was just used as we're in a declining rate environment. But as I showed, over the period 2014 to 2016, we had increases in the repo rate, which influences prime lending rate. So it's not consistent. The nominal rate of interest of 5% is not in keeping with prevailing lending rates right now in Trinidad and Tobago. It is not. It can work to the disadvantage of companies incurring a cost of capital of prime lending 9+, with only an interest payment on judgment at 5%. I asked the government to consider the implications with the FIDIC form of contracts, where it specifies that it's 3% plus the discount rate, which is 9.75%. What occurs in a situation in Trinidad and Tobago when a significant amount of money is owed to contractors? This form of contract is governing the delayed payment, and we are ascribing a judgment, interest on judgment, for the courts to be so guided at 5%. I have also said that a rate of interest on judgment that is lower than the prime lending rate can actually deter people from investing, because in the event of a dispute, the cost or the benefit coming out from the judgment is maybe insufficient to cover the cost of capital. And the rate that is being proposed here today will actually encourage companies to go to the courts. And while we did argue before that the courts has its own discretion, the Honorable Minister of Finance did say that the courts can be so guided by the rate used in the legislation. And therefore, the rate being used will encourage firms, companies, individuals to engage the judicial services in their settling of debt. And this should not be the way we're going. It should be a punitive measure if it gets into court when firms are entering into courts for disputes. So with these few words, I thank you, Mr. Vice President.
Senator Solomon.
Thank you, Mr. Vice President. I'm honored here to make a contribution to this august chamber on the Remedies of Creditors Act as amended in Section 13 by deleting the words 12% and substituting the words 5% and inserting the words, the minister with the responsibility for finance may, by order subject to negative resolution of Parliament, vary the rate of interest prescribed in subsection 1. And we've heard from the Minister of Finance already speaking about the ministerial order that would change the order in the actual act, as the act under section 13 has no number 1 section. Mr. Vice President, what concerns me here today is that out of nowhere, this massive, yet small in words but large in effect, change came about. From 12% to 5% has a massive effect on the judicial system and the persons and the stakeholders therein. Yet still, we've not heard of any consultation. There's no consultation with the stakeholders. There's no consultation with the judiciary. We don't have any sort of consultation with the JCC, the Manufacturers Association, the Chamber of Commerce, the Law Association. What is the Law Association's view on such a drastic and monumental change? Why have we not had an opinion from them? This is a major change in the entire system of judgment debtors. 12 to 5%. We need to have questions asked. We need data. We need to have a study done to understand the impacts this will have on the judgment debt system. I listened to my friend Senator Sturge when he spoke about the small man suffering and the story about the lady who had bought her fridge from Courts. And that is an extremely relevant story that we hear throughout Trinidad and Tobago, where poor people are tied into a system of debt and made to suffer, and it seems they seem incapable of managing to pull themselves out of that dire situation. Does this situation help them? I don't think so. I think that what we need to do is to understand that certain cases deserve certain types of treatment. And a blanket removal from 12% to 5% lacks in-depth understanding of the effects that this would have on our society. How many cases involve insurance companies, for instance? How much is big business affected by it? These are the things that we need to understand. Who are the defendants who will benefit from such a change? A lot of the system is actually clogged because of the insurance system, the insurance companies and their claims. If I can indulge you, I represented a family some time ago. Young girl, her mother and father driving, an 18-year-old girl driving along Valencia stretch, was hit by a truck along the stretch. Terrible injuries ensued. And then began the horrific journey of trying to make a claim. Claim against the insurance company, claim against the truck driver who disappeared, the claim against the business owner who owned the truck. Now this matter took years. The young family did not have any money. It was a pro bono case, and the injuries were severe. It required plastic surgery. It required several operations on the mother and the daughter. The father could no longer work. It devastated this family. Just all emanating from a simple Sunday afternoon drive. Now, fortunately, we managed to get judgment fairly early in the matter, but then began the process of trying to get the actual money. And that is where the real trick in this matter is, and that should not be oversight, because what's happened is the judgment debt starts from that point. The truck driver disappears, can't find him, he's a man of straw. We have to then employ private investigators to go and track down where the assets are, who the people are, go back before the courts with whatever evidence we can get to try and prove to the judge that this is where the assets are. Then you have to get the marshals and the bailiffs involved to try and recoup the losses. All that time, this family will lose from 12% to 5%. Mr. Vice President, that is not fair. That is the sort of people that we need to protect. Now, if you flip the coin and you look at it from the other side of the coin, you have big business, you have insurance companies. They would be looking at this litigation. They have a battery of lawyers, the biggest firms, as Senator Sturge has said, and as my friend Senator Shrikissoon has also said. It is in their interest to enter into litigation, because at the end of the day, they're only looking at a 5% after judgment. They can string out a matter for years and years. A lot of the claimants may be poor, they may not have access to lawyers, they may not have access to the legal system, they may not have access to experts, medicals, doctors, and they may not have the tenacity and the wherewithal to actually follow through the litigation over the years. They have to take time off work. The family that I'm speaking about, the father was a mechanic. Every time he took off work, he lost money. And that is dozens and dozens of appearances. So the point I'm getting at is this actually will front load the legal system. What you'll have is you'll have people saying, well, it's easier for me to just string it out, send the battery of lawyers down, and if we get judgment for 5%, it's not a problem. We can handle that sort of loss because there's a certain amount of people who will lose interest in pursuing that matter. So this is an elitist piece of legislation. This is not for the poor man. This is not for the man on the street. This is for big business. This is for insurance companies and the like. Now, there is something that you need to understand.
Why claims, boy?
All except Beacon, of course, who is known to pay and pay well. No, and I'm not saying that, Mr. Vice President, I'm not saying that it is entirely the fault of the insurance companies. The insurance companies are burdened in their own way. They have their own issues. They want to free up the system. Now, before I'll get into that after I get into the overriding principle of litigation. The overriding principle by the CPR 1998 was to actually facilitate the settling of matters. The overriding objective is to avoid court, save court time. And that principle needs to be followed through with whatever legislation when you interfere with the judicial system. And this interference, I'm afraid, is going to encourage litigation because it is cheaper for the major defendants to go to court. So, bearing that in mind, there is another aspect that the insurance companies themselves need assistance with, and this is something that I was hoping this government would have addressed. Right now, the insurance companies are somewhat stifled in terms of settling their claims. We need to bring to Parliament the Insurance Act. This act has not been laid in Parliament, and this will empower the insurance supervisor and the central bank to properly supervise the insurance companies. Because at the moment, what is happening is the insurance companies are having difficulty getting claims from each other. It's a problem of subrogation, I believe that is Senator Hadid. So between themselves, there is difficulty. And when that happens, they themselves have to go to court, once again clogging the system. So I'm imploring on this government to please bring the Insurance Act to Parliament. Let us resolve those issues, lighten the load, and lighten the court system. There's a movement as well to mediation and arbitration, and the ombudsman, the insurance ombudsman, needs to be more empowered, needs to be more proactive in order to assist to alleviate these types of claims. Mr. Vice President, there is a system and I have to ask myself, who benefits from this piece of legislation? I couldn't figure out why this was coming now, and then it came to me. And I think Senator Shrikissoon hinted on it. And I'll read from an article, if you'll permit me. Anna Ramdas wrote on July 27th in the Trinidad Express, "Pay your damn bills." Oh, my phone has gone dead. Pay your damn bills. The essence of it is that $2.4 billion is outstanding to contractors by this government at this time. If this continues and this bill is passed, judgment debts to those contractors will reduce from 12% to 5%. So you do the maths. 7% of $2.4 billion is a significant decline in the payout that this government would have to pay. And it reads, thank you, Senator Amin, pay your damn bills. This was the call from the businessman and contractor Emil Elias, who told government yesterday it needs to pay $2.4 billion worth of legitimate bills. The JCC, who again I don't think were consulted in this, held a news conference at the Professional Center building in Port of Spain, where its president James Armstrong, Elias, Mikey Joseph, president of the Contractors Association, and others said a deadline of August 30th will be given to government to clear its bills or else action will be taken. So, Mr. Vice President, as an attorney, I strongly suggest that these contractors take action so they can get their judgment bills, their judgment debts in before they lose 7% on their debts. Now, if I calculated right, that means that it's over $350 million with the sweep of this, passing of this act, will go amiss. That is not acceptable. Mr. Vice President, the Minister of Finance had referred to a number of cases, and I thought I would just refer to them as well. He referred to Page against Newman, 1829, and he was making the point that it's a long-established rule that interest is no longer necessary. However, I want to point to him that where this Civil Procedure Act 1833 actually came from, and it emanated as a result of Newman, Parliament enacted a limited statutory power to award simple interest on judgment debts or awards of damages. That's Section 28 of the Civil Procedure Act 1833. That's Lord Tenterden's Act. So whilst we may refer to several of these laws and cases, he also referred to Sempra Metals Limited against Inland Revenue Commission 2007. But I wanted to point out is, in Sempra, Lord Nichols summarized the common law position as follows. A claimant can plead and prove his actual interest losses, including compound interest, caused by late payment of debt, breach of contract, or in tort as special damages, subject to remoteness, mitigation of loss, etc., the cost of borrowing, or the lost opportunity to invest the money. And this is the major point that he made. The statutory discretion to award simple interest is an additional power that does not displace the common law remedy. So, interfering with the statutory interest rate from 12 to 5% has major and far-reaching consequences. Mr. Vice President, I think that this bill is an elitist bill. I think it would cause the poor man to suffer, and I think it is a very surreptitious way for this government to get out of paying their legitimate debts to contractors and people in this country.
Senator Creese.
Thank you, Mr. Vice President. The proposed adjustment of this rate, to me, actually had not been my intention to speak on it, to be quite frank. But I was forced to intervene because while I appreciate much of what has been said on the independent bench, I take Senator Mahaber's point about a mechanism, a formula for fixing an acceptable rate that is not loaded against either the defendant or the respondent. And I take Senator's point about whether all of this is heading in the direction of evading, downgrading, minimizing the debt owed to the contractors. And in discussions with another senator during the break, he was a bit concerned that we all have this broad conspiracy theory, so that the notion that this is loaded against the contractors, they fall under the ambit of conspiracy theory, and that, we could be imputing certain kinds of motives to the government side. And I really didn't want to stand here and lend any kind of credence that we're loading it up now against the government and claiming this is all about the contractors who are owed millions, if not billions. And I thought that there was need to step back and try to get this in the broadest and widest context before opting for a formula for the rate and deciding whether this is all class-based, and therefore, again, the dominant class, the ruling class would win. So this place would continue to be nice and continue to be a paradise. So I thought that really the underlying issues here is the question of financial jurisprudence. And perhaps the question of investment incentives or disincentives. And then the even larger question of constitutional reform / institutional development. And how are we to travel along both roads? When we should be in the parliament fixing laws, and when we should be in the wider society developing norms and mores and institutions. And in a sense, that tells us the way the Calypsonian has that the journey really now starts. Financial jurisprudence. What are the lessons here from the perspective of financial jurisprudence? Well, I think Senator Taurel has made the point clear in terms of his analysis of other jurisdictions and the relationship between the prime lending rate and the rate used for judicial purposes in terms of debt settlements. So I don't think I need to rehash that. I think he made that point eloquently, that there's a closeness and affinity between the two rates, and that the movement from 12 to 5% is a total betrayal of what the international standard is. And in that sense, the government of the day opens itself to the charge as to whose side they're on and how the metronome swings. Because it is clear that if you took some institution, some firm, somebody to court while the inflation rates were rising, and down the road you get the award if this parliament were to make the mistake of moving from 12 to 5%, that a class action suit should be brought against the parliament for such a gross betrayal of the people's interests. Because it cannot be that you place people in this house or in any of the houses of the parliament to institute against the self-same people whose homes you harangued, whose gateways you blocked, whose vote you sought. And then, at the end of the day, you leave them to catch, to find money for lawyers, legal fees, to wait in the court for 5%. The average credit union, certainly the top 10, are paying dividend rates at that level and above, and are lending at rates above that because their profit is usually the spread between the dividend rate and their lending rate. So if you were to take the credit unions as a subsector of the financial sector, you would begin to see that the movement from 12 down to 5 is almost a treasonable act. It is to sell the people's interests down the street, down the drain. It is, in fact, disgraceful. And to come before this August chamber and not peg that to anything is to further compound the injury by insulting our collective intelligence here today. Financial jurisprudence. When last we were here, we had to talk about industrial jurisprudence. So it would appear that the government of the day, in less than a year, are finding themselves crossing the frontiers in the wrong direction. We are moving instead of from east to west, west being the high point of modern democracy. We are moving west to east. We are traveling back in time against the flow, against the ebb and flow of what justice in a post-slavery, post-indentureship state should be like. We have become the creators of our own neo-colonial order. Sad to say, but increasingly true. Clearly, the motor vision eye is closed. Investments, incentives, and disincentives. Again, Senator Taurel made a point as to what the state of things would be for the local businessmen, particularly those in our construction and contractor sector. Because given what the rate they would have secured the monies that they invested in those state contracts, and we all here talking about those state contracts, because those are the biggest contracts around. We don't have a massive enough private sector so that contractors operating solely in that sector could travel very far. Surely we'll have to travel up and down the Caribbean as some of them are doing, because, you know, when you're on the wrong side of the political fence, you better start traveling up and down the Caribbean. So that the question of whether when you move that rate from 12% to 5%, what is the likely impact on the local business sector? Clearly, it sends a clear and resounding message. Start traveling up and down the Eastern Caribbean. Start scuttling and doing whatever else you do when you hit the panic button. Because if the state is moving to move the rate from 12 to 5% when the state owes you, yes, are you planning to go to court and fight that? So where your next contract will be? Which next school, which next highway, extension of highway, which next hospital, extension of hospital, which police station, fire station you're planning to bid for? If you ain't get the memo, hey, check your mailbox. Have one there for you. Get real. In this little 60 by 40 miles that we reside on, You smoke something large, you're dreaming if you think you could survive. If they move it from 12% to 5%, and you go in and fight that, you're planning to sing soca because you had to be out there where somebody other than the state finances your future. So you had to be into soca or chutney. It's only in the entertainment sector you could defy the state and survive. You could ask Bob Marley that. You could ask any of the pop singers that. Only in the entertainment sector you could try that. But it's not just local disincentives. We have a larger debate about attracting investments from abroad because we are in a quest for US dollars. And if you're in a quest for US dollars, foreign dollars, and you're fixing the court rate, the debt rate, you're sending a message to the Trumps of the world as to whether they should bring their business and their money here. Because if in one fell swoop, you cut it from 12 to 5, that's more than half, you know. What are you saying to potential investors? What are you really saying? Is that what you had in your budget speech? Is that what you're writing in the speech that you're going to give at the end of this month? Clearly, the left hand is talking to the right hand. Or one of them is listening, or one of them unplugged there. What they call the thing in the ears again? Williams used to take out? Hearing aid. Somebody either switch off the mic or pull out the hearing aid. But there's a communication problem that is going down. And we had better get it right. Because Parliament is live on streaming. And what has been said is out there now and cannot be recalled. Cannot be recalled. So we've said to the world, right from in this chamber, that we're moving from 12 to 5%. And we cannot recall that proposition. And you will live by the consequences of that folly. Because folly it was. Constitutional reform, institutional development. I repeatedly make the point in this house, on whatever the matter, that we cannot lose sight of the bigger picture. Yes, we are a young, fledgling nation. And I think it was Senator Solomon who made the point about the total absence of consensus, of discourse with any of the stakeholders in this matter. So no prior debate with the Law Association, with anyone on the question of how we should move this rate, how we should deal with this issue of awards from the court, debt-related matters. As usual, we begin where we should end. Debate should end in the Parliament, but begin up and down the corridors. It should embrace our people. But sad to say, one of the problems in a neo-colonial polity is that the old-style authoritarianism of massa lording it over everyone continues to permeate the society. Because it's what we grew up knowing is what we practice. So we tell our children, be seen and not heard. And we tell the people much the same thing, be seen at election time and be heard no other time. So we don't have traditions of consultation. They're usually a charade where we parade our URP and our CPEP support. rather than seriously engaging our people and inculcating habits that are core in any meaningful democracy. Let the sovereign people speak. Why are you afraid of them? But we like to speak through choruses and dramatic arrangements. It's all theater. Meaningless theater, really. Theater in which we demean rather than inspire and uplift our people. So we do not have traditions of constitutional reform, we come back to the Marlborough House approach and concept. It's all up there, it's nothing down there. It's top down, not bottom up. So we are back again in the business of lording it, large and in charge. When I first heard that phrase, it struck me, it stung me, because I thought we had gone past that. Large and in charge. But it's at the core of what's happening, The arrogance of power. But they say pride cometh before the fall. A word to the wise, they say, is always, ought to be, sufficient. But on the question of institutional development and where this connects to that, we tend in our legislation to name the power broker, the person who handles or inspects the scales, as the minister. So it's for the minister, through negative or positive resolution of Parliament, to fine-tune the scales. Why this fixation with minister? A minister is a political animal, came through a political system. You know you're on a better and sounder path when you rely on your institutions, when you encourage the growth and recognition of institutions rather than individuals. And the institutional arrangement that we should be bringing out in all of this is the central bank. In the US, it's the Federal Reserve. In our political order, it ought to be the central bank as the pinnacle of financial independence and independent thinking. So if I were to propose an amendment, it would not be for the minister through any affirmative or negative resolution of the House. It would be the central bank. It's either we put these fellas there to manage the money, as it were, or we don't. It's either we're mature enough to do that, or we are not mature enough. So we close up shop and we go back to being a colony. Like we do like what they had done in Jamaica. I might have referred to that before. I think it's in Jamaica, where they had an assembly as a versus to Crown Colony government, where they voted. This assembly was on the way to a higher form of democracy, voted themselves out of power, voted for a return to Crown Colony government, the only place in the world that ever took place. But there was a reason for it, They wanted to stall the mulatto, the increasingly black class, from coming into the chamber, from coming into the legislature of the day. So that if they voted themselves back into being a Crown Colony government, the governor would appoint the chamber. And those people, their newly found freedoms, who were amassing land and wealth and therefore qualifying to vote and enter the chamber, they could be forestalled. So institutional development in the Caribbean is a difficult task because all the forces are pitted against it, historically. And that is why it has to be our duty to go with institutional development. Because it's that kind of infrastructure as opposed to highways and roads, physical infrastructure. It's the social, political infrastructure that has to develop, that has to deliver us all of us, out of this morass we find ourselves in. It is the only way to go. And that is why whenever we run into problems that strike at the core of our Constitution, we need to opt not for legislation. We need to opt not for reform of various bills and so on. We need to find solutions that are vested in our institutions and institutional growth. And therefore, the amendment I would propose would be one which recognizes the central bank. We went through so much trouble recently to make a point of what the governor of the central bank could or should be. To not at this point in time say, okay, we've sorted that out, and therefore the central bank is up to the task. When would it be? When Twisty comes back to power? You see, it's really all about Taurel and Twisty, you know. Two screws.
Senator Creese, I'm enjoying your presentation, but I really would like you to link to the two clauses in the bill, please. Thank you.
And I was coming exactly to that, Taurel and Twisty. Sparrow tells us there were two screws, and they're opposite sides of the same coin. And at the end of the day, Taurel got us into debt with these contractors that my friends with the conspiracy theory are advocating that is behind all of this. And Twisty's job is to manage that debt that was contracted.
And Senator Creese, Taurel and Twisty notwithstanding, my role is to get us to what is the bill that is before us. Okay? So,
Madam President, earlier time,
I listened.
alluded.
I was not in the chamber, but I was listening to the presentation.
Alluded to the conspiracy by some that behind all of this is the question of the payment to the contractors, and a reduction of the rate from 12 to 5% would affect that debt in a certain way. So the reference to Taurel and Twisty is in the context that one side got us into that debt, and is now the challenge of the other side to manage that debt. That is the context. So it is most relevant. One side would like the debt to be under that 12%, and the other side, it is alleged, wants it down towards the 5%. So that's the reference. So it's extremely valid for those who support the conspiracy theory. And I'm not a member of that club. I believe that our journey to democracy has now started. And that is why I went to great pains to insist that my proposal, rather than the formula suggested by Senator Mahabir, I would prefer to be more akin to the analysis presented by Senator Taurel, Shrikissoon, on the question of the link between the prime lending rate, the repo rate, and any other rate, especially the one the court is going to use, that they should be closely aligned, and that a spread from 5 to 9% or 5 to 12% really is clearly biased in favor of a particular group. And in this case, given our own particular situation where there are a set of businessmen waiting to go to court, clearly, we are putting down Harry Carey on a group of local businessmen who, whatever the faults of any other regime, clearly did their part as per a given contract, a valid contract. And we cannot be in the business of attracting international finance if when they pick up the business pages of the Guardian or the Express, they're going to be reading about pending lawsuits from your local business sector to the state. That cannot be the way to go. And if even you reduce the rate to 5% and therefore force the settlements out of court and so on, that will not be the way to go, because there will be consequences for that with a vengeance. Because any businessman who is able to get his hand on any amount of money at that stage, you want to bet where that money will turn up? You think it will be in Republic Bank? You think it will be in First Citizen Bank? You think it will be in any of the banks registered here? Like I said, they'll be traveling up the Caribbean. And the furthest point north is the Cayman Islands. And then on to the Swiss banks. So we have to understand what it is we are doing. And we cannot play smart with foolishness. Because the consequences will be severe. It will be visited upon our children and our children's children. Whatever took place with Taurel, Twisty sought office and had a duty to be prepared to occupy that office with all that is there. So what was wrong with Sunday night into Monday morning is that there was no sense in Sunday night of an appreciation of all of this and where all of this has to go. No link between our economic problems and our social problems. And that is the core issue, you know. Whether it is crime, and this has implications for crime, eh? Because if we do a number on the contractors, whatever relief they have been providing within the social framework by the employment that they generate and its time and space they buy for all of us, there will be a consequence. Because the lifestyle will be sustained, you know, whether or not it's done through CPEP, URP, contractor. Even the contractors themselves are a form of CPEP and URP, you know. Don't be misguided, you know. They're just better paid, but it's part of the same social framework. So we need to understand that. So we can't put down our work on the contractors, however much we may hate them. Whatever wrongs we may think they may have participated in yesterday's, they cannot be declared an enemy. It's a high-risk business to do that. And we have to understand that all of this is linked to the fact as to who or what we are and where we are. And we cannot conduct a meaningful discussion about anything happening in our economy and the management of debts. Because if we examine some of the the building of the construction sector and so on, and the apparent boom in the southern construction sector outside of the state sector, we know that a lot of it came up the Godino River late at night. And if it came up the Godino River late at night, it has to do with the traffic that starts in Colombia, comes through Venezuela, up through Trinidad and on to North America or Europe. And if we understand that all of these things are related, then we'll be very careful before we tinker with anything in our system that could have immense triggers across the whole slate. Because it will be very easy to drive those businessmen who got a taste for one shipment here, couple mules there, and then pull out and put down some huge structures across the Southland, upstream from the Godino River. And if we don't understand the link between this, and we get into tinkering with anything else in our very fragile young system, we will pay a tremendous price. So I urge the government side to rethink its position and leave well enough alone. I thank you.
Senator Small.
Thank you very much, Madam President. Appreciate the opportunity to be here and to be able to contribute. I have listened intently, Madam President, to this debate, and I had actually several pages of notes, and as things went through, I decided I was going to let it pass. But, Madam President, I've come to this August chamber on more than one occasion and seen relatively simple, benign-looking documents turn into an 8-hour debate or 12-hour debate. And it's because what happens as we start to delve into the issue, it's like peeling and the more you peel and you think you get to the center of the onion, you keep peeling back the layers, and there's more and more stuff being uncovered. Madam President, in concept, this seems very straightforward. I actually have no huge objection to the concept. My concern is rigor. During the presentation by the Honourable Minister of Finance, the mover of the bill, I am not satisfied with what was explained as to the rationale to how we got to the 5%. I am not saying that we should not reduce it. All I'm saying is I am not clear as to how what was used. The government looked at it, or we looked at it, and this is the basis of which we use, and it came from 12 to 5%, and this is the intent in the effect. One of the things we always have to consider, Madam President, and I've been in this chamber, I think this September makes 3 years. What I've observed in my short time here is that often when we have legislation in front of us, we have to consider what is the effect on those parties to whom that particular piece of legislation applies. So it's very clear that whether intended or unintended, a consequence of this legislation being passed as is, moving the rate from 12 to 5%, has the effect of potentially placing those persons who are debtors of the government in a serious situation. Potentially, because not everyone may be willing to go to court. I am not one of the conspiracy theorists. I normally, when I start any process, I start with this page. The page looking like this. The page is blank. I like to listen. And it may be that the drafters, in the way in which they put the things together, did not consider all of the consequences. You know, perception is reality in this world, Madam President. It's not necessarily what you do, it's often how it is perceived by others. And that is so important. Madam President, I want to share, I was actually reading an economist article about, a very interesting article about dishonesty in politics, but I don't want to quote from that. A very interesting article. I recommend it for everyone, an article in the most recent issue of The Economist. Madam President, I want to quote from an article written by university lecturer at the Cave Hill campus, Dr. Tennyson Joseph, and it's about All Always One Lessons from Jamaica. And it's something that I want us to understand, because he says here, and his basic argument is that there's an emerging trend in the Caribbean where there seems to be more and more one-term governments. There's something he calls anti-incumbency, it's his term. And he says, and I quote, that the prevalence of anti-incumbency in the Caribbean is because the governments themselves make themselves agents of capitalist accumulation rather than agents of people advancement. Close quotation. And this is somebody sitting in Jamaica and Barbados, forgive me, and is saying that one of the reasons why governments struggle with trying to understand what people need is because, whether intended or unintended, the capitalists seem to do well, but the advancement of the people doesn't seem to go as well. And I think that while everyone will always argue whether he is right or he's wrong, there's a lot of validity in the argument. There's a lot of validity in it. So my couple of points on this bill is that I am concerned, one, about the process by which we arrive at 5%. I think Senator Shrikissoon, in an extremely, what I consider to be an extremely well-argued discourse about what happens in other places and how it is, whether deliberately or otherwise. I'm not necessarily sold that the other countries deliberately tie their rate to the prime rate. I'm not sold on that. But what I do believe, though, is that it's not necessarily a coincidence that there's a linkage. It's not a coincidence that there's a linkage. That in a lot of places, the prime rate and the rate at which judgments are awarded, there's a relative confluence that they're linked. It appears that they're linked or they're within 1 or 2 percentage points. I buy that argument completely because there's a rationale that, listen, we are in a place where, Madam President, if you take a simple case, someone has a matter pending and it's pending for 5 years. You're awarded $50,000. $50,000, 5 years. If that was at a 5% rate, the rate of inflation destroys it wipes it out. If I was supposed to get $50,000 5 years ago and the rate the court is giving me is 5%, by today that $50,000 is worth, I think I did the calculations, worth about $14,000 or $15,000. So that you wipe it out. So that there has to be some consideration for the fact that our judicial system is not as efficient as we would like it to be. And I'm not getting into the reasons. Let's just accept that it's not as efficient as we'd like it to be. And because of the time lag, if only for that alone, there has to be some consideration to understand that whether wittingly or unwittingly, by moving the rate to 5%, we're actually wiping out the net effect of somebody getting a judgment. And that is a real potential effect. And I'm not sure if in the drafting, whether the parties who are doing the drafting appreciated or even thought about some of these things. And this is why we have the debate. We will always agree or disagree with whatever people contribute. That's fine. But I believe it is rich for us to consider what people are saying. I have listened intently to all the arguments. Some I agree with, some I partly agree with, some I didn't agree with at all. But I believe that where we are, we're trying to do the right by the people of Trinidad and Tobago. And that we're trying to put something in place here that eases the burden. But if in easing the burden, and it becomes apparent, Madam President, whether intended or unintended, and I am not making any claims either way, but let's accept that a consequence of this is that any party who has monies owed from the government and takes the government to court is very likely to be in a losing position. Let's just accept that. And it's not whether that was the intention. I don't believe that. But what I'm saying, that is the net effect. And I do not believe we can ignore the net effect. I'm not in government. I don't have to go face anyone. But I believe that when we're doing something like this, we need to make sure at least put all the arguments on the table. And if the parties choose to go ahead, well, that's fine. That's fine. And this is why we are here. So, Madam President, I also want to say that I listened to the contribution by esteemed Senator Mahabir. There are some points I agreed with. I didn't necessarily agree with his formula. But I believe also it jogs some thinking in my mind, because while what he put forward was something that I think could work, I felt that the element of it disadvantaged the small man. And at the end of the day, forgive me for using the pun of my name, but I also believe that at the end of the day, we have to be considering the effect of something like this on a small man. And as pointed out by Senator Creese and also by Senator Shrikissoon, we have the potential here to have an amendment that could disadvantage the small man. And I'm not sure if the extent to which that could happen has been fully explored. I think it's now come out in the richness of the debate. I've had the benefit of sitting here, Madam President, and listening, and whether I was here or was like you, in another room, but I was looking on, listening to the points that were being made. And I think there's some validity around, one, trying to understand what is the basis. The basis that has been presented, I am unclear, I am unsure, and for sure, in my respectful view, I can't see the rigor. The rigor with which we move from 12 to 5%, the rigor, the analysis to support what was done is not evident to me. It is certainly not evident in the document here, and it wasn't evident in the contribution this afternoon. And I have a challenge with, when we're doing things, Madam President, there's no rigor in the analysis. If there's no rigor in the analysis, then I can call it and say it's faulty. And it's not that it's wrong. It's just that it probably needed some fine-tuning and for someone to spend a little more time with it, understanding the effects of what is being proposed. So, Madam President, that is my one big issue about how we got to where we are. My other issue is that in whatever we're doing, we have to accept the realities of life in Trinidad and Tobago. In Trinidad and Tobago, everything takes time. It takes an inordinate period to get anything done. And if we're putting a rate that has the effect, unintended or otherwise, of whittling away someone who has been done wrong by some other party and wins an award, and then by the time it completes the judicial process and they get the award, and the rate that has been applied is well below the rate of inflation, then you've destroyed the award. You've destroyed the award. Whether it's intended or unintended, again, it's not the issue. It's the fact that that is a potential, a real effect. It's a real potential effect. Because when you look back at what the average inflation rate, it is certainly more than 5%. So that any award is going to be whittled away. And my last point, Madam President, I think that I am certainly not one of the conspiracy theorists. In fact, I argued the opposite. That I believe I don't come out ascribing malice to anyone. I believe that we are here to do our job. But if we're doing that job, and this really shouldn't be my concern, it should be a concern of the movers of the motion. If at the end of the process we're moving a bill, an amendment that has on the face of it the perception that could be easily drawn that this is a bill that advantages the government. We had the Honorable Minister of Energy and Energy Affairs here earlier this afternoon, Madam President, indicating that Petrotrin has an investigation going on for an oil spill. If someone brings a class action lawsuit against Petrotrin for damage to the infrastructure or to damage to the beaches, and then that matter proceeds along the way as it normally any kind of legal action in this country takes. By the time the award, whatever award, and if it is successful, then again, we are actually institutionalizing something that we shouldn't want. So that I have listened intently, Madam President. I enjoy the contributions by all members, including my good friend Senator Henry. But I believe that I think some more, we need to look at what it is we're doing, because I believe there are consequences here to what we are doing that have not been fully considered. They have not been fully considered, and I think that the debate today has allowed for the ventilation of several of those considerations. And as it stands now, I do not support moving it from 12 to 5% on the basis of what I have seen here, because most importantly for me, the rationale for moving it, I am not seeing it. I have no data to support it. There's absolutely no analysis that I can say, well, let me look at the analysis and look at the rigor. Because there's no rigor. And if you give me nothing to work with, then it's difficult for me to support it. Madam President, with those few words, I thank you.
Minister of Rural Development and Local Government.
Madam President, it's a pleasure to join this debate after the parliamentary recess. I had planned to speak much earlier, actually immediately after the Minister of Finance, but I was told I cannot have two bites at the cherry. And I will now have the distinguished honor of wrapping up this debate. The Minister of Finance did in fact say that he has total confidence in the leader of government business in the House. And I want to tell members on the other side and on the independent bench that words of that nature very rarely comes out the Minister of Finance. So I take it with much distinction, and I hope I do him justice in this regard. But Madam President, before I do some rebuttals and comments on the contribution so far, this debate, on the face of it, in my opinion, should have been a simple debate. And it is still at its most fundamental level a simple matter. Okay, it's a matter of on what basis we use to come up with the 5%, whether it is repo, whether it is LIBOR, or whether it is prime. And the whole issue of the other part of the legislation, which gives the minister the power by order through negative resolution to adjust the interest rates. The interest rate of 12% was set 15 years ago. Okay? And this society does in fact suffer from inertia. You know? Inertia in this very parliament. Because of 15 long years, while overdraft interest was 19 and 20%, while prime was 10, 12, 15, 20%, and 17%, the parliament went asleep. And nobody saw it fit to come back to the parliament after changing circumstances for 15 years and say, hey, this interest rate is too high. Because the parliamentary agenda is always filled. And every time we come here with legislation to say, give the minister power through orders to make changes for negative resolution. There's nothing fundamentally wrong with that. Because if you have an objection to it, you can negativize the motion. But it accelerates the system of governance. And there's this tendency, and it rears its head in this House on several occasions. I mean, Senator Creese is a man I totally respect. But there's this animosity towards, not PNM, towards ministerial authority. But that is the system in which we operate. You go to an election to vote in a government. And the government is divided into three areas. The legislature, which is there, the judiciary, which is wherever they are in the Hall of Justice, and the executive. And why the apprehension to letting the executive execute executive authority? It happens in the United States all the time. President Obama and his cabinet runs the United States of America. Very few things they have to go to Congress for in terms of legislation. And even with legislation and with Congress, there's still executive orders of the president. And you see the system reoccurring. I want to throw back my attention to the SSA bill, when everybody wanted to object because the Minister of National Security was demanded certain powers in terms of what he does with the Commissioner of Police and what. And here again, a major part of the objection is not the objection that for 15 years this Remedies of Creditors bill couldn't find its way on the parliamentary agenda, you know. The objection is the minister should not have the power by order, which was really a lacuna in the law because it is in the Supreme Court of Judicial Act. And it was just omitted, and now we're saying we want to put it back in. So, ladies and gentlemen, members of the opposition and the independent, there's nothing so fundamentally wrong with ministers exercising with discretion executive authority, because that is what this democracy and this parliamentary democracy, this Westminster system is all about. The Westminster, when I debated on the SSA bill, I made the point. Everything in Trinidad is not a Westminster, you know. Because Trinidad has something called Service Commission and Presidential Authority. England has none of that, you know. The Queen has absolutely no executive authority in England. And we took our pattern from them. The speech, the throne speech that she reads at the opening of Parliament is prepared for her word for word. The President comes to this chamber and he reads his own speech. So we have to understand executive authority is executive authority. But we have something here called service commissions, again, which is a creature of Marlborough House. That doesn't exist in England. So we have to understand that we operate in a system of governance and a system of government in Trinidad and Tobago. We must let the executive do its job. If the executive abuses its power, you know what to do. Once every 5 years, vote them out. Look, Senator Small says one-term government in the Caribbean. If that is the fact, so be it. Okay? But I can give you the assurance that this administration does not intend to be a one-term administration. All right. So we have 12% interest rates on judgments. For 15 years, nobody did anything. In 2000, I will just go through some statistics here. Commercial banks' ordinary saving deposits was 2.94%, 2000. Yeah, no, that, I know it's savings, but there's a savings side to the debt side too. There's obviously a savings side here. Nobody spoke about it yet. Ordinary savings deposit rates as we speak, 2015, is 0.2%. Commercial banks 6 to 12 month time interest rates, 2000, 7.9%. At 2015, 0.78%. Prime, which has been the topic largely articulated by Senator Shrikissoon. Prime in 2000 was 16.5%. It was set at 12%, which is 4 percentage points less than prime. Prime, as we speak, in 2015, is 8.9%. And then it goes on to give other interest rates, bank, RBC, First Citizens, and what have you. But basically, it has gone from a significant high in 2000 to extremely low figures. Now that, obviously, any reasonable government with changing circumstance has to act. And whether it is on the parliamentary agenda or whether it's trying to slip it in, because it was supposed to be simple legislation. What do you think this honorable House has to be careful with? If we take every simple piece of legislation and expand it to fill a 8-hour day, you will only have one bill passing per day, and in complex bill it will take 2 or 3 weeks to do, and then your whole year and your 5th session and your 3rd session and your 4th session will elapse, and we wouldn't have done nothing meaningful, you know. So we have to understand that on simple legislation, come and make simple contributions, and let's focus on the main points. So we were in a situation where
the minister is winding up, and I think we should listen to him in silence. Those who don't want to be silent have the option of leaving the chamber. Let the minister finish, please. Senator Mark, either you choose to let the minister speak, and please remain silent.
You know what the other choice is.
Okay. So the basis for reducing the interest rate is clear for everyone to see. As to whether we go with Senator Mahavir's suggestion of repo, whether we go with Senator Shrikissoon's suggestion of prime, or whether we go to LIBOR, because LIBOR is another measure that its definition is what the top commercial banks lend to each other. A series of LIBOR rates, and even LIBOR over the years. In 2000, 1-month LIBOR was 6.56, 3-month LIBOR was 6.4, 6-month LIBOR was 6.2, 12-month LIBOR was 6. To 2015, LIBOR is 1-month LIBOR is 0.43. 3-month LIBOR is 0.6, 6-month LIBOR is 0.85, and 12-month LIBOR is 1.18. So you have benchmarks for interest rates. Then Senator Mahabir gave a very scholarly discourse on interest rates and the basis for interest, the cost of capital, the time value of money. All these things come into the fore. But in making legislation, with the way legislation is written, we stay away from formulas. Okay? And that is the flexibility that the minister now has to come through negative resolution to adjust the rate. But in drafting legislation, we cannot put specific formulas because it is not how the drafting department works. Yeah.
Okay. Madam President, I want to thank the Minister for giving way. But, Minister, you indicated that the Parliament really has been rather tardy in addressing some of these matters which warrant changes. And I'm simply asking from you whether the consideration is that the law itself should not be made a bit more flexible, given the relative time period it takes Parliament to change a law to be reflective of contemporary situations. And in that context, when I issued the recommendation for the repo rate has traditionally always been 4% less than prime. Mm-hmm. And what we are talking about here is a 5% interest rate. Repo is currently 4.75. So is it that the government, as part of its justification, did not take the 5% out of the hat, but rather is implicitly linking it to the repo rate of Trinidad and Tobago?
Well, numerically, you will want to think that way because repo is 4.5 and we've gone with 5%. Obviously, we drifted nearer to the repo rate than to prime because prime is almost 9%. But what we are saying is that from a legislative point of view, we don't want to put that type of language in it. And the fallback position is that the Minister of Finance has the flexibility by order through a negative resolution of Parliament to adjust as the circumstances change. Because the Minister of Finance, under the laws of Trinidad and Tobago, is the most important. Himself and the Governor of the Central Bank define fiscal and monetary policy for the country. And if the person who is responsible for fiscal and monetary policy cannot do a simple exercise like this based on the prevailing circumstances, what is wrong with Trinidad and Tobago? Let me now deal with the saving side of this dilemma. And my good friend here, Senator Duki, it is not only on the borrowing side, it is on the saving side. I'll give you an example. The government, through private treaty, and let me just make this point. I'm quoting from the Hansard of the Honorable Minister of Finance presentation in the House. And he says, Madam Speaker, the statutory interest rate of 12% is applied to all unpaid balances. Listen to this carefully. The statutory interest rates of 12% is applied to all unpaid balances when the government acquires land. And it escalates, it compounds, and so on. So it is really a situation that is divorced from reality. Senator Creese spoke about the Point Fortin Highway. The state, through private treaty, but there's a compulsory acquisition order that was passed in the Parliament. So in other words, if you do not want to negotiate by private treaty, you could still be acquired compulsorily. But the state, both administrations have gone with private treaty because that is the more amicable solution because you're dealing with citizens. And you don't want to put the heavy hand on them. By private treaty, NITCO has settled with a lot of landowners, Faizabad, Pinal, Debe, Overpooch, what have you, for substantial sums of money. A lot of that money has not been paid as yet. Okay? But you have somebody now who the state owes who will be getting a fair commercial market value settlement for their property. What would they have done with that money? Not put it in the bank? That's the saving side of it. What would have been getting in the bank? 0.5%. Up until now, their money is accruing 12% interest. That is what bankrupt Plico, you know. That is what bankrupt Plico, when interest was going at 5%, they was offering you 12.5%. Okay, that is what bankrupt Plico. So here you have the state owing you for your parcel, legitimately acquired, 2 million, 3 million, 400,000. Some people, I don't want to quote their name, but some people got 30 million and 25 million for properties along the highway. Obviously, paying 12% in a regime like that is obscene in the current interest environment that we live in. And even 5% is 10 times higher than what the bank will be offering you. So everybody in this debate, up until your humble servant, spoke on the debt side, but nobody spoke on the saving side. Okay? So in setting the interest rate, there are two sides to the coin. Debt, which you will be, on the debt side, you will want a higher interest rate, but on the saving side, because there's a spread between savings and borrowing. Okay? So it is the context of repo with some influence of prime, but more importantly, with a balance between savings and the debt component that the Minister of Finance, judiciously through consultation with respective parties in the Ministry of Finance, we admit that there wasn't national confrontation in the true sense of the word, but we felt these were decisions that could have been taken in-house. We came up with the 5%. And the check valve in this matter, if interest rate change significantly through time, it is always there for the Minister of Finance through negative resolution to adjust the interest rates. And that will save us all these long, unnecessary debates for simple matters of things. No, I'm not saying, I say it in context, okay. Madam President, let me just proceed with another matter here. The conspiracy theory, and Senator Creese was quite articulate, you know. I have no problem, through you, Madam Speaker, with Taurel and Twisty. Because Taurel, in a very obscene way, and sanctimoniously now get up here and speak every Tuesday afternoon. But Taurel left this country with 95% of the central bank overdraft used up. There was a time, Madam President, there was a time in October of 2015 where there were 3 days of cash flow remaining in Trinidad and Tobago.
That's right. That was right.
We met virtually $3 to $4 billion from TNTech, from WASA, from whatever, in 6 months instruments that were due in 6 months after September. Right. We had to go back and refinance the loan into longer term instruments. Almost $4 billion in 6 month instrument. Your 95% of your central bank overdraft used up. And added to that, a $2.4 billion debt to contractors. This is what we're trying to balance our fiscal position with, and I compliment the Minister of Finance again, because he has done an excellent job. That is why today we can breathe a sigh of relief that we haven't retrenched there has not been significant retrenchment in the public service. There has been no significant cut in the very social programs all of you all criticize. Okay, and we have stabilized this country, we have cut expenditure, we have cut waste, so that today we are on an even keel as we celebrate with much pride, knowing that we still have far to go, our first anniversary in government.
Of several terms to come.
So, Madam Speaker, Taurel, but I wouldn't call us twisty. We are untooling what they told in the treatment. So,
You were the speaker.
Senator Creese, you know I lived most of my life in Faizabad, my adult life, and you're a Faizabad boy. So I'm both a Faizabad boy, but more a Mayara boy, but I have interest in both dogs. And you're a man, you are a person I have tremendous regard for. And I respect your commitment to the cause of social justice. And when I say that, I genuinely mean it. I respect your commitment to social justice. But you've made certain statements that you really didn't explain, and to me it was inconsistent in economic logic. By saying that the reduction of the judgment interest rates from 12% to 5% will detract or stop foreign capital inflow into the country. That, to me, doesn't make sense, but the jury is out on that. And you did, in fact, imply, and much to my chagrin, that we acted in bringing this legislation to Parliament very arrogantly, and implying that we are a very arrogant administration. This, to me, is based on false premises. I can give you my personal commitment and the commitment of most of the senators, and especially the senators who are in the cabinet of Trinidad and Tobago, and the entire cabinet, that arrogance is something we abhor in the cabinet of Trinidad and Tobago. Prime Minister.
Abhor.
No. Let me deal with my good friend Senator Mark, my equivalent, so to speak. But I am more equivalent than he is. So let's okay, Madam.
It's like your better half.
Madam President, through you, Madam President, I really encourage the distraction, so I have to accept it. He based this whole conspiracy thing that the drop from 12% to 5% was conspiracy, and what mischief was it brought here to solve. Now that, as I told Senator Wayne Sturge, you could write a spy novel on that, because it is all rooted in what I just articulated here, the interest rate change of the environment. Mr. Imbud said, imagine you get, when he was doing, and I read the Hansard of the lower house, when he said he was doing his first master's, my understanding that he has 3. Okay? So, imagine England in the early 80s, 16% interest on savings. Good? Now you have to pay them to keep your money. Okay? So the interest environment has changed significantly and fundamentally, and that is the justification for this bill and for changes in the law. It is no more, no less. There's no conspiracy, there's no ulterior motive, it's just the motive to keep the judgment interest rates in line with international trend and even with our local trends here. Let me deal with another point on what I say to me was misconstrued by especially Senator Wayne Sturge. Now, But I have to play finance minister today. I have to play lawyer because I'm reading from the Supreme Court of Judicature Act. Clause 25. And it says, in any proceeding tried in any court of record for recovery of any debt or damages, the court may, if it thinks fit, order that shall be included in the sum for which judgment is given, interest at such rate as it thinks fit on the whole or in any part of the debt or damages for the whole or in any part of the period between the date in which the cause of action arose and the date of the judgment. So the flexibility of the judge is not after the judgment. The flexibility of the judge is to include interest in the judgment figure from, if he so deems or so deems, from the date when the cause of action arose and the date of the judgment. And that new figure, which may or may not include interest, will now be, and then 25A goes on to say, every judgment that entered up carried an interest rate of 12% per annum from the time of entering up the judgment until the same shall be satisfied, and such interest may be levied under a writ of execution on such judgment. Okay, so I think we created the impression that the judge had the flexibility to adjust the interest rate. After that, it is the statutory interest that kicks in after the judgment is thing. Okay? The court is now fund us. So, well, I know I'm better than Wayne Sturge, for sure, because he will be the mistake that I am trying to correct. Senator Mahabe, again, a scholarly contribution in economics. He did, in fact, make a fairly credible case for pegging it to repo rate, while in theory, and based on the figure we have come up of 5%, which is more akin to repo, which is 4.5. I've already outlined my case that we don't want to go that way in the legislation. Before to set a rate with the flexibility of the minister can come in at any point in time based on changing circumstances. Because if you set a legislation for repo rate changes so often that every judgment will be subject to a different interest rate and will cause a confusion in the court. Okay? And the calculations will become very, very, very complex. So while in theory, Senator Mahabe, your point is well taken. I mean, from an execution point of view, an administration point of view, or something like that, we want to stay away from it. Furthermore, again, the theoretical basis of your argument is sound. Your proposal that your first 90 days of 0%, second 90 days of 2%, the third 90 of 3%, and the fourth 90, you come up to repo rate. Again, strong theoretical argument, but it's very difficult to implement in a court scenario. Senator Shrikissoon was the equivalent of Senator Mahabe, but he was just articulating a prime rate as distinct from a repo rate. Again, his arguments were very, very theoretically sound, but I make the same proposal that we prefer to go with the rate that was fixed by the Minister of Finance and giving the Minister of Finance the flexibility to adjust the rate by negative resolution. The issue of the saving side, which Mr. Shrikissoon, Senator Shrikissoon missed totally, which he focused on the debt side. And I think that is a very, very, very critical point in terms of what is happening here. The other thing is that a lot of the arguments that were articulated by both the opposition and the independent bench was that the party which the judgment is against, the debtor, who lost the case, based on the interest rate, they can almost infinitely withhold payment just to get the advantage of a low or a high interest rate based on the borrowing rate. While again that is a strong theoretical argument, you can go to the court to levy on your assets. So you cannot just ad infinitum just say, well, I'm not paying.
Exactly.
So that is my understanding of it, but I will leave that to some of the lawyers.
Can enforce a judgment. Yes. You guys have to 12 years. Before that, you could do it.
So Madam President, we came here with two simple amendments to the creditors, the remedies of creditors bill. One is to reduce the rate from 12% to 5%, and while the legislation didn't specify a formula, trust me, there was a lot of analysis that went into it. And secondly, and probably more importantly, is plugging the lacuna in the law, which, unlike the Supreme Court of Judicial Act, the Judicature Act, the Remedies of Creditors Bill did not allow for the minister by order to make the adjustment through negative resolution. That is what we propose here to this Honorable Senate this afternoon. So Madam President, I wouldn't use up my entire 45 minutes. As the acting Minister of Finance, I think it was a pleasure wrapping up this debate. And there's going to be a cabinet reshuffle, and coming events cast their shadows, who knows? But seriously, Madam President, I think it was an honor. I want to thank all the contributors to this debate, the opposition and the independents. I think some of their logic has been very well thought through. Some of the logic was well put forward. A lot of it, obviously, we cannot take on board for the reasons I have just explained. And before I close and I say the key word of I beg to move, I just want to inform this Honourable House that this will be our last sit-in in the first session of the 11th Parliament. And I want to, on behalf as leader of the government, to say that it was an enjoyable occasion. We have met for the first time officially as co-senatorial colleagues. It was a pleasure working with all of you, sometimes more so than others, okay? And in particular, the relationships we have established with the independents. We know what our relationship with the opposition is, but at a personal level, we have made good friends. But at a collective level, we know where your loyalty lies. But that's the course of democracy. So once again, I want to thank all members of this House for a wonderful and productive first year. And with these few words, Madam President, I beg to move.
Honourable Senators, the question is that a bill entitled An Act to Amend the Remedies of Creditors Act, Chapter 809, be read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Amend the Remedies of Creditors Act, Chapter 809.
Minister.
Madam President, in accordance with Standing Order 66-1, I beg to move that the bill be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honourable Senators, the question is that the bill be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favour say aye.
Aye.
Aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause.
Clause 1.
The question is that Clause 1 now stand part of the bill. The question is that Clause 1 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 1 now stands part of the bill.
Clause 2.
The question is that Clause 2 stand part of the bill. There is an yes. Actually, two. Yeah. Okay. And then second, right? All right. Honorable Senators, there are two amendments proposed. The minister has circulated his amendments, and then Senator Mark has also circulated an amendment. Both are in respect of Clause 2. So perhaps we can deal with the minister's amendment. Minister.
Yes, this is a slightly, it's more like a typographical error here. So what we have is the remedies of creditors. It says the Remedies of Creditors Act is amended in section 13, and A, by deleting the words 12% and substituting the words 5%, and B, by inserting after subsection 1 in the following section. But there's actually no subsection 1 in the parent legislation. So this amendment really is to state that after the chapeau, the following paragraph A, by inserting the word, after the word 13, the word 1. So it will be 13.1.
Yeah, you have 13
sub 1. Yes, so it's 13 subsection 1. And thereafter, you will renumber paragraphs A and B as paragraphs B and C. So this is just typographical. But substantially, the bill remains the same without any major amendment. Yeah. Mm-hmm. No, I forgot to answer. I did, yeah.
Senator Mark, we're just trying to work out, because if I put the proposed amendment, then, and the committee agrees, then your amendment
Flies away.
is subsumed in that. So we're just trying to work out, and we're thinking that perhaps we should deal with your amendment first. Okay?
Okay.
So Senator Mark.
Thank you. Madam Chairman, we have not been convinced by the arguments advanced by my honorable friend, leader of government business, as it relates to why this drastic reduction from 12 to 5. But in addition, Madam President, Madam Chair, we have the view that the minister himself has admitted that very long hours went into the formulation of this particular, or decision, I should say, to reduce the interest rate from 12% to 5%. Unfortunately, Madam Chair, we are the Parliament, and we have not been privy to none of these calculations. We have not been made privy to any of the formula that has been used to arrive at this. And therefore, the government has not been able to convince us of the need to withdraw or not to advance our amendment. In those circumstances, I believe that the government must be held accountable for every action and decision that it may take from time to time. And in those circumstances, Madam President, Madam Chair, we are suggesting that if the minister is going to reduce the rate from 12 to 5 via an order, that order should come to this Parliament before it is effected. And it's against that background we are submitting that we amend to subsection 2 in order to give the Parliament the power to understand and to have another opportunity to appreciate the formula that the government has used to arrive at this 5%. And that is why, Madam Chair, we are suggesting, with your leave, that the government in 2, that is, in subclause B, delete the word negative and insert the word affirmative. So that would encourage the government to be more accountable, not in words, but in deed and action, and more transparent with the Parliament, and through the Parliament, the people of TNT. And therefore, Madam President, I beg to move that this particular amendment is designed to bring the government to book and the executive to account as it relates to this. No. So, Madam Chair, that is our justification for the affirmative and to remove the negative.
On the face of it, if we go through the robust procedure of setting the interest rate in a very scientific way, based on somewhere between a spread of prime and repo, and with the technocrats at the Ministry of Finance, the Minister of Finance himself, and some help from the central bank, I think more often than not, we would get it right. And if you have a negative resolution, if perchance on one occasion you have major queries in why are you setting the interest rate so high or so low, you just bring your motion and to negativize it and we'll debate it. But to debate it as a matter of course every time this change takes place, I think it's largely unproductive because we already set the template in which this operates.
We want it to be affirmative, Madam Chair, and we maintain our position.
Yeah, Madam President, a question to the Honorable Minister Khan, and that is, with respect to this type of legislation, what is the convention? For example, in 2000, when the rate was set at 12%, what was the standard set at that time? Was it affirmative or was it negative? I'm just trying to get the consistency in the Parliament for bills such as these with respect to affirmative or negative.
The Supreme Court of Judicature Act does in fact has the same clause, negative resolution. And actually this was always the intent of this legislation, but it was just a lacuna. And the Petty Civil Court Act, I'm being told, has the same formula for negative resolution.
It's quite consistent.
Yeah.
It's making it consistent.
Yeah.
Honourable Senators, the question is that clause 2 be amended as follows. Delete the word negative and insert the word affirmative. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Oh, I apologize. I apologize. Let me just... So the question is, my apologies. The question is that clause 2, the question is that clause 2 be amended as follows. Delete the word negative and insert the word affirmative. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The amendment has not been passed and accepted. Honourable Senators, the question is that clause 2 be amended as circulated by the Minister of Finance. You want to?
You can read it out.
Yeah, no. So I will now read out the amendment that has been circulated on behalf of the Minister of Finance. Clause 2, A, insert after the chapeau the following paragraph. A, by inserting after the word 13, the word 1, sub 1, and B, renumber paragraphs A and B as paragraphs B and C, respectively. So those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 2 now stands amended as circulated and now stands part of the bill.
To the Senate.
Honorable Senators, the question is that the bill now be, as amended, be now reported to the Senate. Those in favor say aye. Aye. Those against say no. The bill as amended will now be reported to the Senate. Honorable Leader of Government Business.
Madam President, I wish to report that the bill entitled An Act to Amend the Remedies of Creditors Act, Chapter 809, was considered in committee and was approved with amendment. I now beg to move that the Senate agree with the committee's report. Standing Order 69-1.
Honorable Senators, the question is that this Senate agree with the committee's report on a bill entitled An Act to Amend the Remedies of Creditors Act, Chapter 809. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Leader of Government Business.
Madam President, I beg to move that a bill entitled An Act to Amend the Remedies of Creditors Act, Chapter 809 be forthwith read a third time and passed. Standing Order 69-2.
Honorable Senators, the question is that a bill entitled An Act to Amend the Remedies of Creditors Act, Chapter 809 be now read a third time and passed. Those in favor say aye. Aye. Those against say no.
No.
I think the ayes have it.
A bill entitled An Act to Amend the Remedies of Creditors Act, Chapter 809.
Leader of Government Business.
Madam President, I beg to move that this Senate do now adjourn to a date to be fixed.
Honorable Senators, the question is that this Senate do now adjourn to a date to be fixed. Those in favor say aye. Aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to a date to be fixed.